Okay, Rachel, great backdrop for that case. I got my two great guests, Linda Kenney, Baden, in studio with me. Hashtag Jersey Girl. How are you, Linda?
Good. Nice to see you, Bob. Been missing you. A great studio, new studio, long cry. We're the best.
I know. And listen, Linda is a real pro. She's done some huge cases. She's been an assistant prosecutor, defense attorney, big cases across the country. So it's always great to have her perspective here. She'll be hosting a little bit later. And then I have my hashtag 4041. I'm a little jealous, Linda. He was on with Jesse earlier.
Traitor.
I know, and other hosts. Yeah. But Gene Rossi from Virginia with the DOJ for 30 years, over 30 years. They have actually got a war room called the Gene Rossi War Room at the DOJ. I think that is a great honor. He has tried over 100 trials. He's a prolific litigator. He does criminal defense now, and I'm sure his clients are getting awesome representation. I love having these two guests, guys. We got a real short breath. Gene, let me throw to you. Well, you know what? You've been talking all morning long with Jesse. I'm going to Linda. Ladies first. Linda, yes. Prosecution's opening, I was very moved by.
Yes.
And then the defense attorneys open, and I was very moved by that.
Yeah,
what do you think of the case? I mean, it's a little hard to prove people are outright lying what's in their mind or how they're writing reports. What's your game, real quick?
Well, the problem you have here is that this all comes in light of Chicago, right? And the judges are not immune to this either, about how the Chicago cops in the past have been lying, have been corrupt. There was a cop named Burge who got false confessions. So people see this. Even the judge, by the way, looking at this, is this part of the old school, or did they just get caught up in something and they didn't mean to lie?
Yeah, and Gene, just to go to you real quick, you're out of the doghouse now. I'll give you a reprieve for being on with Jesse earlier today. But Gene, these kind of cases are kind of hard to prove, especially when they're taking hearsay information and it gets kind of passed. I've seen this happen in investigations. I know you have too. In a non-nefarious way, one person says one thing, it goes to another person, and it becomes a fact when it's not. What do you think?
I think that's a good defense. March is at the end of the informational trail, so I think his defense is the best. I relied on what others told me. I put it in a report. And if they gave me bad information, I didn't know that. I basically put what they said on a piece of paper. It's sort of like an accountant in a federal tax case. The client gave me bad information. I relied on it. Don't charge me, charge the client. It's the same theory.
Except, wasn't there something, and I'm not sure I heard correctly because I'm trying to listen with an open ears, that they got together and watched the videos?
Yeah, but listen, that's the prosecution and opening statement. They got together. They're trying to make it look like that's a nefarious thing. We used to do that all the time. You get together, you pull the videos down as you're doing an investigation in order to see if you're losing anything that could be fresh at a crime scene that you may forget.
Like he wasn't attacking them. That's the problem.
Yeah, and that's going to be the big thing, Gene. But this goes back to cop logic and prosecutor logic. I've been involved in cases where the cops feel that they've been threatened or that somebody represents a threat. And I think the defense did a really good job at explaining that based upon the actions of Laquan McDonald. Now, it is a problem when there's a question of, were they backpedaling? That is the account that Van Dyke gave, as opposed, or was he coming after them? But nevertheless, people see things differently. They view things differently. I've been involved in cop investigations where they really had no idea what happened in a violent encounter.
Is it my turn, Bob?
Yeah, you got it.
You left them speechless.
Hey, by the way, Linda, I still love your glasses.
I'm just for you, Gene. And they make me see what's happening here very well, by the way.
But Bob, it goes to what we've been talking about for a couple of weeks at least. When police officers are on the scene and there's a tense, pressure cooker situation, your mind moves a lot differently, and what they see versus what the video shows could be a lot different. That could reflect what they put in the report. You, as a Monday morning quarterback, may not think that Mr. McDonald's going to charge you, but when that officer's looking at him and knows that he's high on PCP, you're thinking that guy's going to come at me and kill me.
Right.
So that's the dynamic.
I agree with you. It's all in the interpretation. And we have both been involved, all of us have been involved in trials where we show a witness a video or a picture that we feel is irrefutable, and you see this shocked look on their face, and they still stick with their testimony saying that the picture or the video, which is true, doesn't show everything. But let's go to the prosecution's opening statement and see how they're laying out this case with regard to their theory that this was an orchestrated, to Linda's point, an orchestrated thing from the very beginning in order to cover for Jason Van Dyke. We are gaming the cop cover-up trial. That is the sequel to the Jason Van Dyke case, where he was convicted of second-degree murder for having shot 16 times and killed Laquan McDonald. These officers are on trial for allegedly covering that up. There is a fierce battle going on between the prosecution and the defense. What we just heard, Linda, the prosecutor say, was that they were, in one of the reports, they listed Walsh and Gaffney as victims. Now, I'm going back to the piece that I'm talking about, how cops are trained. I'm just telling you how they're trained. When the car tire is punctured, and she's calling a scratch on the window, that was a scratch created by a knife. And when they're not listening to officer commands, multiple officer commands, and they're using the vehicle to try to cut him off so he can't get into that Burger King, I understand why they say to themselves that they were victims, that they were being attacked, they were under assault or potential assault with the guy with the knife who actually used the knife against the police vehicle. That's how cops think.
I know that's how they think, but you know, there's no death penalty for scratching the window of a cop car. There is no death penalty for knifing the tire of a cop car.
Yeah, but
cops aren't supposed to think like that. They're only allowed to shoot with deadly force if their life is in danger, and that's the problem we have there. If they knew that, and they knew this was a bad shoot and tried to cover it up to save one of their brethren, that's a crime.
Well, I have to respectfully disagree for this reason, Gene Rossi. If Laquan McDonald was placed into custody, he would have been charged. The prosecutor is saying he was involved in non-violent offenses. No. He would have been charged with robbery on the incident previously, burglary for going into those vehicles and stealing the radios. He had a violent encounter with the gentleman who called 911. He refused to listen to officer commands. That's not a crime in and of itself. Walking down the middle of the street on PCP, assaults a police vehicle, if you will, by puncturing the tire. That would have been at least criminal mischief or other stuff. And in other words, these cops are in the red. I'm just taking the defense's side of this case right now. They see somebody who is a danger, swinging a knife, who's used a knife against a cop car, is not listening to cops, and they look, I'm talking about the guys writing the reports, hearing that, as that the cops, and all those people there were potential victims.
Bob, it goes to what I've said several times. When you are high on PCP, and I did a lot of drug cases, I have been told by cooperators and even the ones who I charged that when you're high on PCP, you will do extraordinarily crazy and violent things in a split second. So those officers know that. They have to know that. And when he was walking down that road, given the other history before what happened the last 15 minutes before, as a defense attorney, I would say, okay, he shot him 16 times, but let me tell you what's going through his mind. This is a man who could at any time charge him like an animal. Right. And he could have been killed because the guy had a knife. Now, the video shows things that aren't consistent with that, but that's the best argument you could make. Right. And that would say...
And again, sorry, Gene, for purposes of this trial, this is about officers who are doing an investigation and are now being charged for allegedly trying to cover up. And we're going to get into a little bit of the reports versus the videotape in a moment. There's a live shot that you see in the courtroom. We're going to go to break. We'll be right back.
Officer Spontane.
Sergeant in the Chicago Police Department, who I can still hear in my earpiece. The testimony is going on with the prosecutor asking questions about policies and procedures. Gene Rossi, I'm curious. I'm going to ask a really technical evidential issue because I know our people in the chat room and follow this network love the style of the experience and experience of the lawyers. Could I make an argument as a defense lawyer that, Judge, what is having the policies about the reasonableness of the use of force and all of this about when this case is about whether or not they falsified the reports and it's a factual question, not a legal one, as to whether what the officer who shot Van Dyke was appropriate or not?
The training of an officer, and Sergeant Schnelly's done a lot of training, goes to the state of mind of all three of those officers. Because from what I gather here, the officers are taught basically a legal writing course, which I used to do, is, okay, here's when you need to do a report, here's how you do a report, and here's the criteria you use to make a valid report. All that is highly relevant if they went through that training, and I assume they did. It's very relevant.
And Linda, listen, we know that, and having run an agency, I don't condone people not following the rules and procedures. But we know that people also cut corners, not necessarily for a nefarious purpose, but that theory, right, is a little stretched when you're dealing with a really long investigation that March was involved with in terms of cutting corners. It was very intensive, the investigation. The conclusions are what's at question.
Well, Bob, not if your intent is to mislead as to why this was a bad or a good shoot, depending on, and the officers here, the prosecution argues it was intent to mislead, because you can't both violate the law and violate the policies and write reports that after you all get together and huddle. And by the way, the problem with the huddling is that they only had 3 of them or maybe 4 of them, and there's other officers who weren't on the same team that they were on. So it goes to the intent that they absolutely deliberately did it in this case.
Yeah, Gene, I mean, the fact is, though, I think that the defense would have an argument that there may be some policies that aren't followed. Ladies and gentlemen of the jury, you go to work. You have policies. You have procedures. Let's be honest. How many of you follow them to a T and maybe try to skirt here or there? It doesn't necessarily mean you're being nefarious. But when you're dealing with, again, the demonstrable evidence of that videotape versus the conclusions that March came up with, it's really hard to reconcile it being anything other than, quote-unquote, nefarious.
Right. And if I'm a defense attorney in that case, and it's a tough case, I would try to put in evidence, and with a bench trial you get a lot more flexibility. I would put in evidence that, you know what, we had this policy, it had A, B, C, and D. Hey, nobody ever followed it. We did E, F, and G.
Right.
And if that is the policy, if you will, of that department, that they ignore, you know, the things you're supposed to do, that would be part of a defense that really they didn't commit a crime. Were they sloppy and negligent and went outside the box? Yes. But were they criminal? No.
Well,
if they have that evidence.
That's the prosecutor's opening statement, that a lot of these things parrot one another or what have you. And this officer, the sergeant, is saying only the person that used the force is supposed to fill out those reports. But culturally, that may not be true. And let's not forget, some love the cut and paste because they think it brings consistency, because they don't want to have inconsistency. They do that sometimes for very legitimate reasons. Maybe not so in this case. I love having you two on. This is a great, great case to break down. We're going to go to break. We'll be right back. Let me know when he comes back. Okay, welcome back. We are breaking down the cop cover-up case. There's a little testimony going on right now about policies and procedures, but we love our chatters who are supporting this network at Dan Abrams Production. And I know we got some changes going on here, Linda, and new studios and new distribution platforms, but we love the fact that our chatters are going to follow along with us as we move it to the next level. And because of that support, we're able to continue to give these kind of shows. So real quick, both Beefy Butcher and NC White Shark, I believe it was, asked a similar kind of question I want to throw to you and Gene. Gene, you still there? Okay, let's go with Linda. All right, defense attorney,
right.
What is your strategy? How does it change from a bench trial to a jury trial? I'll tell you, let me just start off for number one. I also want to know your opinions about whether you would have gone bench trial. Personally, as a defense lawyer, I never would have gone bench trial. So answer one, would you have gone? And two, how do you change your lawyering?
Well, in this case, Bob, I happen to be ready for that question, because I would have gone, because the judge in this question was known to be a police-oriented judge. As a matter of fact, there's an article in the Chicago Tribune about that, that she was, a lot of people filed substitutions of judges that they wanted with their defense attorney because they felt that she helped the police, and she was also friends with one of the defense attorneys. So yes, I would.
You know, I'm going to tell you something where I completely disagree.
No, wait, you have a second question. You asked me a second question.
Well, okay, we can't go on forever now. You got to give me a quick response to how do you change your lawyer
You don't
style?
have to. You can do the technical stuff. You don't have to bring it down to plain English.
Right. Okay. You don't have to do all the gyrations. Gene, I disagree with this. If she is a cop's judge, she may very well, the judge, be offended by what went on here, and you're leaving it to a jury of one. And to me, it's a lot easier to hang a jury with one juror who just sits there and says, I'm not doing it to these guys. Van Dyke got hammered. I'm not, these guys are going to get in trouble in other ways. I have done one bench trial as a criminal defense lawyer, and that was only because the judge in chambers said before the trial, I think your guy's not guilty. And I still hesitated.
With the utmost respect, Bob, I totally agree with Linda.
2 against 1. Cut that guy's mic.
Yeah.
Go ahead.
Linda, you are absolutely right. I would have waived jury, go to bench. And because when I was in the Eastern District doing federal cases, I did about 90 juries, but the rest were bench. I actually love bench trials. And there were times when defense attorneys in a criminal case would waive jury because they liked the judge. And it ended up being a very good move. The second thing about strategy is when you have a bench trial, you don't have to worry about foundation, all that stuff, chain of custody. Yeah. The judge is going to let it in. And it's a lot more relaxed when you have a bench trial, in my view. Well,
you know what? Here's my response retort real quick back to you. One tough Italian Jersey guy can withstand disagreement from 2 of my great guests. Now, it's great analysis. I appreciate it. Let's go back to court. I love when that happens, Linda, because it gives us more time to be able to discuss this case with great experts like you. So long as I don't hear the trial in my ear, I'll be able to do that without much confusion. Gene, if you were going back to how you try a bench trial differently, there was some critique of the defense lawyer from March in this case that he was kind of like over the top for a bench trial. And you know what I felt when I was listening to it on the train ride in here today? I listened to the whole opening. Number one, I thought he was very effective. He was very good. Number two, I don't know the man, but my suspicion is he tries a lot of jury trials, and it's really hard to shake that out of you when you're doing a bench trial. So his style, that's his style. I think he's an effective lawyer, probably very good in front of a jury.
I didn't listen to the opening, so I'll take your views, to the bank. But we had an attorney, I won't mention his name, in the Eastern District, and whether it was a jury or a bench, he had the same demeanor, the same flamboyancy. And you're right, they sometimes can't dial it down a little bit. But I got to say this, depending on your judge, it always depends on the judge in a bench trial, some judges would probably say, okay, Mr. Rossi, come on, this is a bench trial. You don't need all the histrionics. Tone it down a little bit. You're not in front of a jury. I don't think that judge did it here.
Yeah, Linda, I'd say maybe there were 1 or 2 instances where I thought the judge was going to say, take some zip off the fastball. Right. But I think that if I were sitting there as a judge, I would understand the gravity of the case, the media attention to the case, but also that you got an old salty dog there, and it's really hard that, when you just have those tendencies to be the way you are.
Yeah, and also remember, this is a high-profile case. Everyone in Chicago is probably aware of this case. And if these officers are acquitted, they have to go back into the community. 2 of them, I think, or at least one of them is still on the force. He's suspended, but he's still on the force. The other 2 have to still live in the community. So you want to have, you want to show passionately for people that are out there that you believe in your client, whether it's a bench trial or a jury trial.
Yeah, hey, guys, I'm going to ask you a personal question. Like, when I'm on trial, whether I'm a prosecutor or a defense lawyer, and you're in the middle, I cross hard, fast, and as you can imagine, right? So that's my style, and every style is different.
Right.
But I remember one time sitting at a restaurant on a Friday after a cross-examination, a pretty hot cross-examination of a witness, where my wife said, and we were just talking about whether the plumber came to the house. She was like, hey, well, why didn't he come? And what time was he supposed to come? And she's like, hey, Bob, I'm not being cross-examined. I'm like, you know what? Sometimes it's hard to take that out of you when you go back into your personal life.
Oh, yeah, but you're still married, so obviously you did.
Yeah, no.
And you have a beautiful beagle.
Yes, I do. But do you find that it's hard to turn it on, turn it off?
Yeah, it's tough, especially when you're in a trial that is very, very, it's just emotionally, and you're living and you're breathing it. You don't really relax. Even if you're out to dinner, you don't relax.
Right. How about you, Gene? Do you find yourself sometimes have to try to consciously turn it all off?
I'm going to do a shout out. My wife, Diane, and I have been married happily for 33 years, and she has the same comment. Don't treat me like one of your defendants in a trial. Don't cross-examine me. Because my pet peeve, even in private life, is when they don't answer a yes or no question. I go crazy.
Yeah, right. It's yes or no, but it also goes to the idea, guys, of a bench trial. It's also the way you're examining the witnesses that's relevant in a bench trial, because the histrionics, or the way that you would normally do it in front of a jury, if you will, where you really can get revved up and do the appearance, you can't do with the judge. It gets back to Gene and Linda's point that the judge could probably say, hey guys, enough of this. I get it. This is a bench trial. You don't need to do it because the jury's not here. Hey guys, listen, we're going to go to a break. We'll be back on the other side. Stay tuned. Okay, so Sergeant Larry Snelling testifying on behalf of the prosecution in this case about policies and procedures. Linda, yes. I thought that this guy obviously makes a very, very good appearance. He's obviously very knowledgeable. Talked a lot about time, distance, and shielding. And we'll get the audio out of our ear, and we'll be able to. What are your thoughts of him so far?
Yeah, no, I think he's a very good witness. He talks about weapon delivery systems. So you know if there's a weapon, there's a threat. If there's a delivery system, there's a threat. But then he says intent, and he doesn't see any indication of intent looking at it. And that the officers also could go behind the car to avoid this kind of knife attack, because the last thing you want to do, Bob, is last thing you want to do is kill somebody. That should be the last indicia in the officer's mind that I'm going to shoot. But when we know from the original trial, that's what the partner, Jason Van Dyke, the partner to Walsh, said.
You know, I wonder, Gene, that if, people got cute by half in the beginning of this, and that if things were different, Gene Rossi, that you could have an argument that reaction is slower than action. He was showing violent tendencies, walking down the street with an ominous, illegal Class 2 felony knife, had already assaulted the vehicles we talked about before, and then there's that little piece of the video where there's a turn. And if the officer had said, I thought that he may have had a gun, and not that I was going to be attacked by this knife.
Yeah.
And even though there wasn't a gun afterwards, because of the PCP, because of the erratic behavior, because of the violence, and the manner in which see right now, if you watch this video, he's got his hands moving, there's he's got the knife in his hand, he's not listening to officer commands, they're getting out with guns, he's not listening to that, there's lights blaring, and it's hard. The video won't necessarily show the turn, the look, the thing that the human mind could perceive. Do you think that could have made a difference, and that maybe they got locked in to their testimony and couldn't get out of it?
Yes, I do. If you freeze frame that video, when he crosses that little bit of white, he did turn his body just a little bit. And it goes to what's in the officers' minds, both of them. When somebody is high on PCP, that little turn could be the prelude to him lunging and attacking at least one of the officers. It's a very subtle thing when he's walking, but he does turn maybe about 3 inches, and that could be that jerk.
And I'm sorry, Gene, to cut you off, but he's also got his hands at his waistband area. He's got a hand in his pocket, potentially his pocket. He's got. I mean, a cop confronting this has got to be alarmed, and especially as they're trying to cut him off so he doesn't get into that Dunkin' Donuts. I'm sorry to cut you off.
I will say this, though. That sergeant is fantastic. When you have somebody that you know is on PCP is irrational and explosive, stand behind the car, use it as a shield, and both officers are walking towards him, and you're sort of, stirring the pot. Try to calm the situation. And I didn't get the feeling those two officers were trying to calm the situation.
Well, Gene, Linda, listen. I'm not saying it was right to shoot the guy 16 times. Okay, Laquan McDonald. 6 foot, as I understand, 180-pound guy. But, they got to do something. And you just can't let the guy, well, just hear me out before you disagree with me. You just can't have a guy threatening people in where he's robbing the radios, to the point the guy calls 911 and thought he was going to get assaulted. Not listen, here he is, little officer commands, hands down by the waistband, flashing a knife. Cops telling him to stop at gunpoint, and he's not doing it. I mean, what do we do? I just want to flip the script, no pun intended, a little bit. If that guy broke loose and stabbed somebody in that Burger King.
It's not. There's a 6-foot fence on the other side. He's walking away. They call for tasers. Tasers about 30 seconds away.
They don't have any idea how long the taser's going to be. I'm just saying. Wait a minute.
7 police cars.
Linda, honestly, let me ask you. If God forbid, God forbid, somebody in your family was driving by there or somebody was walking by there and got stabbed by this guy, the cops would be on trial for malfeasance for not having taken more aggressive action with him. I'm just saying that's the way it would be.
But it's fact specific and they're not. And the only person who pulled this gun is the person who's been convicted already of second-degree murder. And these cops then said he lunged at them because they know without that lunge that their life is in danger. This was a bad shoot. And that's what this case comes down to.
Well, I'm not disagreeing with the legal issue here, Gene Rossi, as to whether or not it was reasonable to use deadly force, at least shoot 16 times. But what I am saying is the cops are in a very, very difficult position with a person like this. And those who are never been on the street, those who have never had an encounter where they've had to take a command control of a scenario, don't know that you're damned if you do and you're damned if you don't. Now, I wish that there would have been another way to neutralize the threat. But if this had gone sideways and he had either attacked another officer or a pedestrian or somebody inside of that Burger King or Dunkin' Donuts, whatever it was, then you know they would have been on the crucible for that.
You're absolutely right. Damned if you do, damned if you don't. If something bad had happened either before or after, the police would have been held accountable for that, an omission. But this is so egregious. The more you know what's amazing when you stop and look at each frame, and I don't think they really did that as well in the jury trial. When you stop and freeze each frame, it really shows that his actions were very much across the line. Across the line.
Right. Okay. Well, Gene, Linda, thank you so much. We're going to go to a break, and we'll be right back. Okay, that's the cross-examination of the attorney for Officer Gaffney, who's on trial right now for falsification of police reports, obstruction of justice, and official misconduct. That is Sergeant Snellings, who has been subject to cross-examination. So, Gene Rossi, I think the defense scored some points in the beginning of this about the form, about bringing out the person being an attacker, what the video shows with respect to what Gaffney was doing, the uniform, the stuff that I talked about before, the failure to listen to officer commands, that you have to watch their hands because they could represent a danger, asking him to drop the knife several times. All that was good, I think. But can you explain to me, I may be missing it, what is it with all these questions and objections that are going on, or failure to know how to ask the right question? What are your thoughts about all that? Because he's asking about the actual forms that have been moved into evidence and checked off by the defendant officers in this case.
I have to tell you, I disagree with the judge's rulings.
Yeah.
This guy is an expert who talks about the forms, training the officers. And if anybody on the planet knows why certain boxes and certain lines are crossed out or checked or filled in, it would be Sergeant Snelling. So those objections that were sustained, I don't know, maybe I have to go to take an evidence class again. That's number one.
Yep.
Number two, because it's a bench trial, as a prosecutor, I used to sit there like a potted plant, and I hardly ever objected. Because it's a judge trial. I mean, they let it all in for what it's worth. How many times have we heard that? I'll let it in for what it's worth. So the prosecutor, he's doing a good job on direct and defending his witness, but it sounds like he's defensive. And I would have let a lot of those questions be asked, because maybe those questions and answers could eventually help you on redirect.
Yeah, I first of all, I agree with you completely. I don't understand the judge's ruling. I was trying to stretch on a number of occasions to get it. He's an expert. These documents have been moved in by stipulation into evidence. The document was testified to, in fact, surrounding the document were testified to on direct examination. And you usually give a wide berth on cross-examination to test, one, the credibility of the expert, and the fact that the prosecutor's indicating, Linda Kenney Baden, that, well, I didn't show him the grand jury testimony. Well, that's your bad that you didn't do that.
But here's what's going on, okay? I agree with the two of you for a couple things. Was that Fahey for Officer Gaffney is doing a good job. I agree with that. He made a distinction between armed assailant and active resistor. He's trying to show that indeed Laquan McDonald was an armed assailant. But the report that he was talking about at that point was the report for when the tire was popped blocks away. And then what the attorney did did, and this is why the objection got sustained, started saying, well, if you raise your hand like this, trying to mix what happened later on to what happened in the report earlier. And I think that's where the judge cut it down. And I disagree with you. I think this judge is actively listening. She doesn't want anything in the record that doesn't.
Yeah.
She's female. She's
Linda,
great. I knew I'd get Bob there with that one.
She's great. Okay. How about this?
Can I just say
the fact
I gotta say something.
that I would be? Wait a minute, Gene. I'm still in shock over the comment. You know, hashtag me too. She hasn't hit me yet. She hasn't pinched me yet. But here's the thing: I'd be thinking about that judge. I don't care if she's a woman. I don't care if she's a man. If I'm in a defense right now based upon what I believe to be inappropriate sustaining of the prosecution's objections, I'd be wondering maybe I should have went jury trial. I'm going to convince you guys by the end of this case that was the move to make. But let's go back into court. They knew we wanted to keep talking, Linda. So, Gene, yeah. So, I mean, seriously, let me, go back to it. To me, again, when you were dealing with a scenario in which the government has produced a police witness expert, that you should be given wide latitude. I respectfully believe that it was a constant sustaining of objections that had nothing to do with timing or the knife being raised over the hand. That's something for the finder of fact to say wasn't relevant. The question wasn't premised on proper facts, Gene. It's not a basis to exclude cross-examination about whether or not, as I heard it, you check off the box assailant when he's acting in that manner.
I agree. I do think that they made a wise decision by waiving jury. I'm going to fight on that one. But I really think that on cross-examination by the defense attorney, especially in a bench trial, if I'm a judge, I'd never be a judge. I'm going to let a lot of leeway occur. Absolutely. And here's why. Because if the government loses and they're acquitted, they can't appeal. But if the defendant is convicted, you're just handing to the defense side grounds for appeal because you improperly excluded evidence.
Yeah, and Gene, I don't mean to cut you off. I think that we actually saw, all three of us as lawyers, the lawyer was kind of befuddled. He didn't know how to, you could tell this happens. This is a legitimate question in his mind. I don't understand why it's being sustained. He was having a real hard time at it, but we have another defense attorney for the defendant Walsh that's got a crack at cross-examination. Let's go back into court. Okay, welcome back. That is Todd Pugh, the attorney for defendant Walsh, cross-examining Sergeant Snelling. Gene Rossi, they've done a good job, the previous lawyer, but I think blood was drawn on this witness, and I'm going to tell you why. It kind of goes back to some of the other points that I've made. One thing is an expert witness, and you should protect against as a lawyer. It's shocking to me that the prosecutor did not show this expert the entire file on the case, including the 2 hours of grand jury testimony that his client gave. What are your initial thoughts on that, Gene?
That's malpractice. As a prosecutor, you want your expert to have every nugget of information. For one reason, cross-examination, it's like cross-examination 101.
Yeah.
Did you look at this? Did you look at this? And if they didn't look at all this information, that chastens and damages the credibility of that expert. I thought the worst comment that came out of Sergeant Snelling, and I like this guy, is where he said that more information could have changed my opinion.
Well, we're going to get to that in a minute, Gene. I'm sorry. We're going to get that in a second. I don't want to jump the gun. I just want to cap off the point that so our viewers and our audience loves, especially people in the chat room, to know. It is 101, like you said, that you give your expert every single piece of information in the case to avoid the very thing that just happened with that defense attorney, which seriously nicks the credibility of the expert. Not only mentioned the judge is listening to this case and saying, wait a minute, they didn't have all the information. Now let's go to your point, Gene, substantively. Substantively, he indicates that the video, the lawyer was really effective. He's kind of like this slow-paced, easygoing guy, but that's where you could be on either end of the spectrum. That on the other side of the moon, or the dark side of the moon, as he was referring it, you can't see what's going on, and the officers had a better vantage point. And to your point, Gene, that you brought up there, he indicated that if he had more facts from the case, it would have been better than just to have to rely on the video, because the video doesn't show anything. Ouch!
Ouch. And Bob, is this Thomas Breen for Walsh?
Yes, it's Todd Pugh for Walsh.
Oh, must be another attorney. Okay. No, going back, experts can be phenomenal witnesses until cross-examination. And Sergeant Snelling is a good example of how his direct exam was pretty darn good, but that's the beauty of cross. And this attorney did an excellent job. He brought out the spinning that occurred, the split second, how it could change in a heartbeat when you have somebody on PCP. He didn't look at the 2 hours of test. Are you kidding?
Yeah, you know what, Gene? I actually feel bad. I've done this. I've eviscerated expert witnesses based on the failure to have everything. It's a common sense thing. You can't say as an expert that having 2 hours of grand jury testimony of the officers explaining what you can't explain. He said the witness, well, they only know it's in their heads, and I didn't have any other data. You as a lawyer put your expert in harm's way, in jeopardy. You compromised your case, not to mention perhaps the truthfulness of your expert's testimony. So I feel bad for the sergeant that he was put in that position. But then again, you know, who knows what pressure was applied on him, or if he'd asked for it and just wasn't given that information, which is something I'd love to find out. If he said, I need more, and they said no. And why? Yeah. If you're a judge or if you're a fact finder, would you be saying, well, that's really curious, they wouldn't give him all the data?
Right. And my cross would be, did Mr. Rossi, the prosecutor, tell you you didn't need to look at this 2 hours? Did you ask to look at the 2 hours? And the prosecutor's sitting there, I've been there, where my face gets red because I now become a potential problem with the credibility of my own witness.
Right, and Gene, listen, this all surrounds one thing that we didn't get a chance to talk about, but I'll just say it straight away before we go to break, and that was that this whole round and round and round we go. It's almost like the Abbott and Costello, who's on first, when talking about what's reasonably objective, what's reasonable, what goes on between people's ears. And the defense lawyer did a very, very good job about bringing out what's objective, because let's face it, folks, the defense lawyer points to the fact that everything we do as human beings has a level of subjectivity to it, and that's why two witnesses telling the complete truth could be at the same scene. And I know Gene Rossi's been in this scenario, any good trial lawyer has, and they could observe the same exact facts and have two completely different conclusions in 2 seconds. Am I right or wrong, Gene Rossi?
You are 100% right, as always.
And you know what? There's no better place to take a break than Gene Rossi saying, I'm 100% right, as always. We'll be right back. All right, welcome back. They took a break now on that cross-examination of Sergeant Snelling's in the cop cover-up case. Myself and my boy Gene Rossi, hashtag 4041, we were talking about a sergeant who I feel was left a little naked, or a lot naked, as far as a witness is concerned, because the prosecution decided not to give him all the data in the case when he's testifying as an expert, including grand jury testimony. It was important enough to have the cops in the grand jury for 2 hours giving an explanation of what he did and why he did it, but it wasn't important enough to give it to your expert who's going to take the stand in a trial where they're trying to take his liberty. Gene, it's shocking. These are the things where I'm going to get worked up. I was peaceful today. I don't get it.
You know, I criticized a defense attorney in one of your prior shows, and I got a nice email, actually a nasty one from that attorney. I do not hesitate to criticize prosecutors, because I was one for almost 30 years. You were a big-time prosecutor. When they do something that I think is just crazy, and I'd love to hear the explanation someday, this is crazy not to give the 2 hours of testimony by an individual whom you're opining on. I don't understand it. I don't understand it.
As a prosecutor, there's a different cadence, Gene, than there is for a defense lawyer in terms of making sure you're getting to truth. You swear an oath to do justice. Defense lawyers don't do that. Not that there's a problem with that. Their job, their responsibility is different. And one would have to ask why it would be that these sophisticated, smart prosecutors decided to withhold crucial data from their expert. I got to go into court and show you one thing, Gene, from the other day, a tape of some medical examination testimony, and let me talk to you about that on the other end. And we got a couple of chatter questions that I'd like to get to as well. So if you have any more in the chat room, I'm going to try to knock 2 or 3 of them off real quick on the other end. Hey, Gene Rossi, you remember that, what is it, Arsenio Hall used to say things that make you go, You know, I'm thinking to myself, am I the only one, and I'm sure I'm not, getting the irony of the fact that a state's witness not only has sloppy reports, has no idea of how it changed or who changed it or how it got edited, and there's 2 different versions in a case where cops are being tried for falsification of reports?
People in glass houses shouldn't throw stones, and it's the pot calling the kettle black.
Yeah, I mean, it's wowsy on that. Yeah, and so, Gene, I got 3 areas I want to hit with you real quick for our chatters. HJ1 Mad City asks, and this is a really good question. The challenges as a defense lawyer when you're working with multiple defense attorneys and their clients at trial. What are your thoughts about that?
When you have multiple defendants, multiple attorneys,
yeah,
that affects, I've seen this many times in my cases and ones I've observed, when you have so many defendants and so many attorneys, on your cross-examination strategy can change dramatically. You don't want to rehash something that another attorney has done or will do. Because when you get up there, you want to make your performance precise and strategic, so your cross-examinations may be much narrower. Plus, you don't want to bring out on cross something that could hurt your guy and maybe help the other guy, so that when the jury deliberates, they acquit him and find your guy guilty. So you're walking a tightrope.
Right.
Walking a tightrope.
Gene, I would call it the good, the bad, and the ugly. I've seen it done where it's been good and a force multiplier for the defense attorneys. But I've been involved in cases, both as a prosecutor and defense lawyer, where the guy has to get up after a witness got destroyed and actually rehabilitates the witness because they couldn't stop from the golden rule, which is, or in law, when you stand well, stand still, and they actually destroy the case. Second, so great analysis. I agree. It's hard to assess there, HJ1 Mad City. Thanks for the question. The difference, Gene, between no contest and guilty, this is something that came up before, or the NOLO pleas, and Jersey doesn't allow them for a reason, but what are your thoughts?
There are 4 types of pleas. There's not guilty, there's guilty, there's this weird thing called Alford, where you essentially say, I'm guilty, but I'm innocent. It's a crazy Supreme Court case, ALFORD. Then there's nolo contendere. Nolo contendere is you are waiving your right to a jury or bench trial on guilt, and you're asking the court to sentence you, but in no way are you admitting you did anything wrong. That's a nolo.
Yeah, and in Jersey, they will not allow that because they believe that it's unfair to make somebody pay the consequences for something that they're not guilty of. So you have 2 choices, guilty or not guilty. But there are a lot of people that suggest that's problematic, too, because they may be not guilty, but they don't want to plead not guilty. They want to plead guilty because they don't want to face the consequences. So a NOLO would be a good middle option for them. We can go round and round the merry-go-round about the merits of that. Last one, BB314. Says, what if this judge is a hung jury? BB314, I don't know if you're kidding around, but I've actually seen judges at a bench trial declare themselves hung. How about you, Gene?
I have never seen a hung. I have never seen a hung by one juror, the judge.
Yeah, I have, actually. We thought it was the strangest thing that when the judge said the case, I'm not even making it up, I am a hung judge, and basically went through an explanation how he could not come to a conclusion of guilt beyond a reasonable doubt. It was very kind of convoluted. You could just say not guilty, but that's what the judge said. Hey, great questions, guys, in the chat room. Really appreciate it. Going to break. We'll be right back. Sorry. All right, Gene, let's get to it, right? I've got a couple of notes here I want to go over with you because it's been compelling testimony. These lawyers did a good job. We talked earlier about our chatter's question about, is it hard when there's one or two defense lawyers or three defense lawyers? Not if they're doing things in tandem. And I was wondering, is McKay just going to go over old territory? But no, he actually, to me, was a force multiplier to the previous cross-examination. He started with the law, Gene, and talked about all the reasons why they're allowed to use deadly force under Illinois law, and I was surprised that this had not come out earlier. He then went into talking about the attack of the previous citizen who called 911. He talked about how Gaffney and McGillicuddy had their tire punctured, the windshield broken or scratched up. He admits, the officer, that he is an assailant at a certain point in time, and that he's indicating the witness here that the victim McDonald. In fact, McDonald created a state of victimhood. I'm sorry, I'm just trying to read off my rough notes here, which is something the defense has been wanting to do for a while. And Walsh and Van Dyke were excited. They were in fear. It was a high-risk situation, split-second decisions. They don't have the luxury of watching a video. Gene Rossi, at certain points in time, he got such good answers. I think he was shocked.
I give him an A+. Jim McKay, congratulations. That was a textbook cross-examination. It showed the right amount of respect, but aggressiveness. And wow, did he land some blows.
Now, Gene, I got one more question with you, and I know it's not fair, okay? And I know, but we love to do this. We love to talk about trials and strategies. I'm wondering if this guy had testified in the Van Dyke trial and had Van Dyke not taken the stand. This is what we do. This is why we wake up. And I got Linda's getting ready to host here. She's sitting right next to me, and everyone shakes their heads as lawyers. But people in the chat room were talking about this kind of thing. Could this have been the kind of testimony that would have assisted Van Dyke? And had he not testified, could you see reasonably there could have been a different outcome, or at least a hung jury?
There would have been at least a hung jury. And I got to stress, Sergeant Snelling is fantastic. It's that he's just being subjected to a great cross. The best witnesses after a cross can lose their credibility.
Okay, Gene, we got to go into court, but I want to just add one point to that. Now you got Snelling saying things like, I know that now. It goes back to the point that he's sitting in that witness chair and he's like, yikes, man, I'm taking fire because they didn't give me all the information. They're giving him the information. He's giving them great answers. Let's go to court on redirect examination by the prosecutor. Okay, so let's break it down before I have to go for the day and the rest of the week into next Monday. I mean, parting is such sweet sorrow because I love what's going on here in this case. You got good lawyering on both sides. It is the cop cover-up case. Sergeant Snelling's on the stands, the experts for the prosecution. The defense lawyers did a phenomenal job, and it would be really interesting to myself and my friend Gene Rossi as to whether this would have had an effect on the Jason Van Dyke case, whether it has an effect on falsification of police reports in this particular trial. We don't know, but it certainly was interesting commentary. I'm going to be signing off. Gene Rossi, hashtag 4041. Thank you so much for your excellent commentary. Linda, Kenney, Baden, LKB is coming up next. I'll see you next Monday, 12 to 3. Have a blessed weekend.